Well, first and foremost, welcome and thanks for joining us for today's session, which will focus upon the implications of Brexit upon employment and immigration law. My name is Sarah Alford and I'm Head of Employment Law here at Berry Smith. I'm delighted to say that Glyn Lloyd will be joining me today. Glyn is an immigration lawyer and is the owner and founder of Newfield's immigration law practice based in Cardiff. As always with these sessions, we intend for them to be as practical and as relatable as possible, so you have not least a number of takeaways from the sessions. In terms of the format for this session, now I'll be kicking off and I'll be going through the impact that Brexit has on UK employment law. I think the reality is that my part should take around about 10 minutes or so. I'll then hand the baton over to Glyn, who will be walking us through the implications from an immigration law perspective. His part will take around 45 minutes, which will allow a little bit of time later for a Q&A session. And if you can, please put any questions you have in the Q&A box rather than the chat box. And then hopefully we'll have time to come on to those a little bit later. If you do have any specific queries, questions, or if we don't get to all of the questions today, please do feel free to pick up with either myself or Glyn, obviously myself for employment law issues, Glyn for immigration issues after the session. We're friendly, we're more than happy to help and try and steer us all through these really, well at the moment obviously difficult and challenging times for all businesses. Okay, kicking off employment law and Brexit. Well, by way of background really and context, a significant proportion of the UK's employment law comes from the EU. So we've got discrimination rights, collective consultation obligations, TUPE, so the transfer of undertakings, family leave and the working time regulations. Now, EU employment law has been incorporated into UK law in a variety of different ways. So we've got some laws are secondary legislation and they're typically regulations. You've got the transfer undertaking regulations, TUPE, got the working time regulations, for example. And we've got other laws that are primary legislation and they tend to typically be acts. So for example, the Equality Act 2010. Now, EU-derived employment legislation, both secondary and primary, remains applicable in the UK post-Brexit unless and until they're altered by the UK government. The other source of law, other than legislation, is obviously case law, and that's case law that's handed down following decisions of the European Court of Justice. Now, a bit different to legislation in that the UK courts and tribunals don't actually need to follow existing and new ECJ, European Court of Justice decisions, and can depart from them, and I'll quote, if it seems right to do so. Now, that being said, I think that the reality of the situation is likely to be is that given the lack of guidance on what courts and employment tribunals should take into account in deciding how to either regard or potentially disregard European Court of Justice decisions, and that a failure to follow a potentially relevant ECJ judgment, European Court of Justice judgment, is likely to make their decision more appealable. We expect employment tribunals and the courts to take a cautious approach and follow new European Court of Justice decisions and indeed existing ones in most situations. Saying that, going forward, in terms of legislation, as we predicted, in return for a tariff-free and quota-free trade deal, the UK has actually agreed that it will not reduce those employment rights below the standards that already exist on the 31st of December 2020 in a manner affecting trade or investment. So what does that mean? So although the UK is free to diverge from EU law to a certain extent, so long as obviously it doesn't impact on that trade and investment, it doesn't seem likely in our view that major changes will be made to existing employment law rights, or that significant gaps, if you like, are going to open up, indeed in the short term. I think in the medium to long term, we are likely to see gaps arise in a couple of areas, and I've listed those on the slides, and I'll walk you through what I think could potentially be the gaps in these areas that we're likely to see arise. Now, first and foremost, we've got discrimination law. Now, the Equality Act 2010, as you may already know, it gives wide-ranging protection to individuals in the UK who've suffered discrimination. And the Equality Act is significantly influenced by both EU law, EU legislation, I should say, and indeed EU case law. So those decisions handed down by the European Court of Justice. Now, I think that any change to the existing regime governing direct discrimination, indirect discrimination and harassment seems really unlikely. But some commentators have suggested that free from EU constraints, a cap actually could be imposed on discrimination compensation. So at the moment, we've got a cap on unfair dismissal compensation, but not on discrimination compensation. We could see in the medium to long term a cap being imposed on discrimination compensation following successful claims. Secondly, family leave and pay. Now, rights to parental and family leave in the UK are a bit of a mixture, really, of rights deriving from the EU and rights originating from the UK. Now, we've got the relatively new right to shared parental leave and the right to request flexible working. Now, those rights are purely UK in origin. I think although some critics consider the family-friendly rights to be a bit of a burden on business, I think there's very little political appetite for their repeal or even watering down. I think as we go through the next couple of years, we could actually see an extension of rights around family leave and indeed pay. TUPE, the transfer of undertakings. Now, as you may well know, TUPE does attract and can attract a lot of negative press, but the principles that employees in a transferred business should transfer over with it is often useful for businesses. And what we find is that actually it's incorporated and priced into many commercial agreements. And although there's many businesses, and I know a couple that would like to get rid of TUPE altogether, it seems more likely that the government actually may make small changes to make TUPE more business friendly. So, for example, I think the government may choose to make it easier to harmonise terms following a TUPE transfer, which is not currently permitted under EU law. So what that means, obviously, is individuals employed by the incoming business should stay on their current terms and conditions rather than harmonise those with the existing terms. I think, like I said, I think the government may choose to make it easier to harmonise those terms following a TUPE transfer. And then finally, holidays. Now, the right to statutory paid holiday is well established, and of course it would be deeply unpopular with both workers and indeed trade unions alike if it was removed. I don't think that's going to happen, okay? And the right's obviously broadly accepted by most UK employers. However, there are aspects of the right to paid holiday that the government may want to amend. Now, what we've seen over the past couple of years is various European Court of Justice decisions being handed down on holiday pay that are actually very problematic for UK businesses. So, for example, we've got the right to keep accruing holiday whilst on sick leave, for example, and the fact that holiday pay should be based on a number of aspects of remuneration, so commission, bonuses, for example, not just basic pay. I think the government may want to retain a right to paid holiday based on maybe their basic pay only, and maybe with limited rights to accrue and carry it over into new holiday years. So I think in summary, I think short term, we're not likely to see many, if any, changes open up in employment law as a result of Brexit. I think medium to long term, it's possible, if not actually likely, and I think those are the main areas that they will focus on, that the government will focus on in terms of change. I'm now going to stop sharing my screen and hand over to Glyn. Thank you.
Thanks so much, Sarah. Let me just share my screen. Just quickly checking if you can see my slides.
We can.
Perfect. Okay. Thanks so much, Sarah, and thank you for the kind introduction. So, unlike some of the pace of changes that you might see in employment law. In immigration law, things have changed quite dramatically at the turn of the year. Immigration is a very political topic, and so for that reason, it's often the subject of change. And even though we've gone through a quite significant alterations to the rules as of the 1st of January this year, already we know that there are further changes to the provisions coming to place this year. So what I'm going to look at today is what do you need to do as a business if you are contacted by a candidate, and really for you to understand what right to work checks you need to undertake. Because of course, with the ending of freedom of movement, that is, with Europeans now not automatically being able to have working rights in the UK, it does mean that the number of checks that we have to undertake to ensure that we are employing somebody lawfully, the number of checks have increased because more people will now be subject to visa conditions. So I'll wrap this up as part of a UK immigration overview. I'll focus a little bit on what used to be the case before 31st of December, for you perhaps to understand sort of what changes and the impact of those changes that were introduced on the 1st of January, and then looking at how we should treat any workers who will require sponsorship going forward. I will also cover EU nationals who were in the UK before the 1st of January, because of course there are transitional provisions in place to protect the working rights, the rights to the NHS, rights to schooling, rights to residence in the UK for those particular individuals. And so, but we obviously do need to start differentiating between which European nationals fall under the new regime and which ones are protected, and what can we do as businesses to verify that. With some closing comments then perhaps on some of the practical steps you can take as employers going forward. So looking first of all then at recruitment and rights to work. Your starting point will always be the Home Office right to work guidance and checklists. And there are two lists in place, a list A and a list B. And essentially anybody who applies for a role at your organisation and they present a document to you which appears on this list A, it means that those individuals have permanent rights to work, that you simply need to take a quick photocopy of the relevant document, and then they have no restrictions going forward. List B covers those individuals with restricted rights to work. So they would typically be your visa holders. And so that list prescribes the documentation that you need to have in place to verify whether somebody has the right to work. It's very important not to veer away from the documents that are set out on list A and list B. If you find yourself recruiting an individual and you do so, but you perhaps rely on a document which isn't listed on list A or on list B, and it's subsequently discovered that that individual has no rights to work, then as an employer, you could be fined up to £20,000 per worker, because that would amount to illegal working. And only 2 weeks ago, we acted for an employer who took a person on the basis of a fake ID card. It was very, very good fake, and a letter issued by DWP confirming the individual's national insurance number. Well, that letter confirming the national insurance number doesn't appear on list A or list B, and so the employer faced a fine of £20,000, which was reduced down to £15,000 for first offence. We got the employer off the fine. We challenged the Home Office, but nevertheless, it does demonstrate sort of how challenging the Home Office can be, and to them, it is a very black and white situation. So the point being, before taking somebody on, before recruiting somebody, look at whether they can produce a document which appears on list A or list B. As I said, those people who would be on list A, those with permanent rights to work, will be your British citizens. Be aware that a lot of British passports overseas look very similar to British passports that are issued from within the UK. So ensure that you've got the correct type of passport. Also, EU workers and their family members who are in the UK before the 1st of January 2021, they enjoy permanent rights to work. I've also referenced Commonwealth citizens with rights of abode and those with some form of indefinite leave to remain or permanent residence. But it'll be very evident from the documents that they produce whether or not they have got that indefinite leave to remain status or permanent resident status. And then that leaves then the residual category of those with restricted rights to work. They will now be your EU workers who entered the UK for the very first time after the 1st of January, together with your conventional non-European visa holders. So what do we need to do as businesses in order to recruit a person who requires a visa? Bearing in mind now that we're talking about your traditional non-EU workers, so perhaps your Australian worker, but also perhaps your German worker who hasn't been in the UK before the 1st of January this year. Well, we can't differentiate between that German and that Australian worker going forward. So in most cases, as an employer, you'll need a sponsor license. And really for most employers, there are two options. You have a skilled worker sponsor license or an intra-company transfer, an ICT sponsor license. An ICT is really for those businesses with operations globally, including Europe. And it's there to enable employees within different parts of the group company to be mobilized and to spend some time assigned a project or assigned a certain piece of work in the UK. ICT visas are time limited, so you can only sponsor a person up to 5 years and they have to leave the UK. Whereas under the skilled worker route, this will cater for those businesses who perhaps only have a UK base, but not necessarily so. And the individual will come to the UK, they'll accrue some 5 years residence under the skilled worker route, at which point then they can apply for indefinite leave to remain and potentially British citizenship afterwards. So skilled worker provides options for both the employer and for the employee towards a more permanent employment basis. The role has to be skilled. So before December last year, the role had to be at degree level or above. So that would have restricted a number of workers from undertaking particular jobs in the UK. Whereas since December, the skill level has reduced. It's been diluted to NQF level 3, and that's the equivalent of A levels. So really now, businesses can sponsor your Australian or your German worker on very administrative roles, executive officer roles. It doesn't need to be something that's based at degree level or above. That said, there are some minimum salaries that apply, and generally speaking, and I do say generally speaking, that rate is 25,600 gross, or the going rate for the particular role. So the Home Office list all of these jobs which individuals can be sponsored to do from within the UK. And for each of these roles, there will be a going rate. That going rate has been decided by an independent committee. And so we need to ensure that we do pay that as a gross packaged salary. Allowances, etc., aren't counted. So we do need to ensure that minimum threshold is met. However, we can trade points this points-based system that Boris Johnson and his government have been talking about. We can trade points and essentially reduce the salary threshold, so effectively reduce the pay of these individuals if, for example, they meet certain other criteria, for example, by having a PhD or a PhD in a STEM subject, or for example, if the job is one of a number in a shortage occupation list. A financial requirement applies, so the individual has to demonstrate that they have a certain amount of money in their bank account before coming to the UK, essentially almost a month's salary. But that can be certified, that maintenance can be certified by the employer. So the employer can say as part of the visa process that, listen, if John comes in from Germany and he gets into financial difficulties in the first month of his employment, then as an employer, we can provide some funds or support to him during that first month of his employment. Importantly, an English language requirement applies to the skilled worker route. This can be satisfied by having a degree, either taught in the UK or a degree taught overseas, which was taught through the medium of English, or of course, if you're a majority English-speaking national, and the Home Office have a list of defined nationals within that category. Prior to December last year, as an employer, we generally had to advertise the job for 28 days before we could even entertain the idea of sponsoring an overseas worker. That is, protect our own workforce before looking overseas. That has now been scrapped, and so we do not need to carry out that resident labour market process. That saves at least about a month and a half to 2 months from the visa process. And it relieves businesses from a lot of management time spent on interviewing, undertaking setting up job advertisements, and those job advertisements were quite onerous. You had to specify the specific salary and the package and what have you. You had to take screenshots. All of that has gone. Previously, before the 1st of December, the number of overseas workers were capped to no more than 1,750 per month across all UK organisations. That cap has been suspended, and there used to be an additional restriction or additional cap in place, meaning that those who were sponsored under the skilled worker route could only be in the UK for 5 years, after which point they had to invest a lot of money in applying for an indefinite leave to remain application, whereas now that cap has also been removed. So actually, what the Home Office has done is, although freedom of movement has ended, a lot of the previous restrictions that were in place, which was stalling or slowing or delaying visa processes, those have now been removed. So far more workers are now entitled to the UK visa. There are other categories which we can employ individuals in. They include those entering the UK as investors, those coming to the UK on government authorised exchange schemes, youth mobilities, students. I'm going to discuss in the next slide. So the point being is that if an individual comes to you with a visa and says that I've been granted permission to be in the UK under one of those categories in that top list, it means that you can employ them really without restriction. And that's important because, of course, more people are going to need visas in order to be in the UK now. There is a graduate route being introduced in July this year, so that enables businesses to employ international students, which will include EU and non-EU students from July, and that's a 2-year visa. There's no sponsorship requirement, there are no minimum salary thresholds, etc. So a very easy visa, and you would normally put the burden of applying for that visa onto the particular student. The student will apply for that visa, and then with that they can apply for roles. So it's aimed at attracting more students to the UK. It's a lucrative part of the economy, but also to enable students that bridge between completing their studies and then going down a full-blown work visa route. Actually last month, a new visa was introduced for Hong Kong nationals as a result of security issues in Hong Kong. And again, these individuals, and we're certainly assisting many of them now, coming to the UK, setting up businesses, contributing towards other businesses, investing in other businesses in the UK, but also here as employees. And again, they have full unrestricted access to the workforce. So that leaves us with a second category of visa holders. So if you as a business are you receive an expression of interest from somebody with a skilled worker visa on ICT visa, with an innovator visa, or some of those sector specific ones that I've referred to on that slide, the chances are you cannot employ them straight away. You might be able to get around it by applying for a sponsor license in your own right. But essentially, if somebody is sponsored by a UK company under a skilled worker route, it means that the individual is largely assigned to that employer. So the visa marries up with the employment relationship. So if the employee wants to move to another employer, then the next employer needs to pick up the requirements for sponsorship. Now, just for you to be aware on sort of the practicalities around that, if you find yourself in that situation where you're an employer and wishing to take on a worker who is sponsored by another company, it isn't a very quick job. You really need to be looking at a 2-month stretch if you haven't got a sponsor license, to enable you to apply for a sponsor license and to get the visa through, because we can't sponsor the worker until you've got your license in place. And then once you've got your license in place, the employee then needs to submit a personal application to join you as a company under your license. And you cannot begin employing that individual until the visa is approved. That has been problematic over the last year because COVID has slowed everything down, but the Home Office have now resumed priority processing, which means that individual visa applications can be prioritised and decided within as little as 24 to 48 hours. Unfortunately, getting the sponsor licence, there is a priority process, but the Home Office have a random 10 companies per day, and they select those 10 companies and offer priority service to get the application for a sponsor license approved quickly, i.e. within a week, but it is a random process. So if you don't get selected as a company for an expedited sponsor license application, then you might find yourselves having to wait, I say, 1 to 2 months for your sponsor license to be approved. But once your sponsor license is approved, you can sponsor as many people as you want under that license. The license lasts for a period of 4 years and is renewable in 4-year increments. I've mentioned students. Obviously, there is this new graduate route that's going to come into play at this coming summer. In the meantime, if you are looking to recruit students, particularly on a seasonal basis, then you can still recruit those international students, but the working entitlements are restricted to 20 hours per week if they're studying at degree level or above. If they're not at degree level or above, then their working time is subject to 10 hours restriction. And again, make sure that you've got evidence of their entitlements to work and their entitlements as a student in the UK. But just be careful before you go about in employing students who are still registered as such at universities. You don't want to be employing them over the working hour entitlements. There are other visa routes, which I'm not going to mention too much today because they are family-based routes. So if somebody's married to a British citizen or is in a relationship with somebody with some form of settled status, if you have a Commonwealth citizen with a UK-born grandparent, they can apply for UK ancestry. And these provisions all entitle the individual to work without restriction in the UK. So if you do receive an expression of interest from a candidate and they present a document showing one of those 4 bullet points, then you are entitled to employ them without sponsorship. So just as a reminder, Look up the UKVI, that's UK Visas and Immigration Rights to Work guidance, because that sets out what you need to do in order to employ somebody who is on a temporary basis in the UK. It also sets out the penalties that apply. These are largely civil penalties, as I've mentioned. Getting it wrong can lead to an employer being fined £20,000. And as I say, it's reduced to 15,000 for a first offence, but that's per illegal worker. There is a criminal offence if you knowingly employ somebody who has no lawful rights, but you can obtain a statutory excuse. Now, a statutory excuse there's an online portal to the UKVI, and you can verify whether a person has working rights or not. So if they present you with a residence permit and it has a particular endorsement on it, you go onto this online portal, and the Home Office should respond within 5 working days, confirming whether or not the individual has permission to work. This might be helpful if the individual has applied for a visa, but hasn't yet received a response, hasn't had the application decided. Because whilst you can pay additional fees to have a visa application decided quickly, they can be quite expensive, up to £800 on top of all of the other fees, and that's not readily available to all staff. And so if you don't go down a priority route, then the standard visa processing time is about 8 weeks in the UK. So you might find yourself, or a worker might find themselves in possession of an expired visa, but they've applied for the next visa enabling them to stay in the UK, but they haven't had a response yet from the Home Office. So they're in a bit of limbo. In those instances, you must, as an employer, access the Home Office's right to work guidance and use their employer checking service online tool, and the Home Office will verify whether or not that individual can work with you. You'll get a traffic light response. One will be red, in which case it's no, please do not touch. Otherwise, you go into the territory of employing somebody unlawfully. Or alternatively, they'll say, yes, you can employ this individual. And this positive notice has a shelf life of 6 months. So it means that as an employer, you have the comfort of knowing that over the next 6-month period, you can continue, or you can employ this individual. So as an employer, just be absolutely sure that you undertake the appropriate checks. So if somebody presents you with a document, and to avoid discrimination, we would be applying these same checks if we knew the worker was British or not. We would need to see their original document, the document which is set out on list A or list B. We would need to check the document before the employment commencement date. So either in the latter stages of your recruitment process or in your induction day or induction process. Check whether there are any restrictions on the person's leave. So if they present a residence permit to you saying, okay, I'm Chinese and I've got this skilled worker visa, there might be an endorsement on the residence permit which says that they cannot undertake employment with anybody except for this particular employer. And then you need to take a record of the document. So take a copy of the front and the back of the document and ensure you diarise the expiry of the visa, of the permission to be in the UK. I've mentioned the UKVI's employer checking service in my previous slide. That's the online tool to check whether somebody has the rights to work. And you're always required to consult that UKVI employer checking service if the individual has an outstanding application, if they're an asylum seeker, or if they fall within those 2 categories at the bottom, but you very rarely see those nowadays. There are opportunities for people to visit the UK if they're not British to undertake particular activities as a business visitor. So this involves the individual entering the UK to do a particular activity. You do not need to sponsor them. The individual might not even need a visa to enter the UK in the first place. but the types of activities that they can do in the UK as a visitor are highly restricted. So you can't generally employ somebody in the UK whilst they're here as a visitor, and you cannot pay them. And payment in terms of Home Office, from Home Office perspective, that includes a payment in money, payment in kind, but also includes enabling an individual to undertake work in the UK on an unpaid basis. So do check that anybody entering the UK, perhaps from your overseas operations, check that they can come in as a visitor, but make sure that they're always on the payroll from their business outside the UK. You don't want to transfer them to the UK payroll, and that they're only going to be here for a short period of time to do these specific tasks. There are a number of activities in these 2 slides, but I understand that we're going to be sharing these slides after the session, so perhaps you can have a quick look at those in your own time. Just mindful of your duties not to discriminate. Obviously, immigration requires you to discriminate in some senses of the word, because of course you have to differentiate those your people on the basis of their nationality, because we have to determine whether or not a person has entitlements to work. But the checks that we have to undertake for that have to be carried out for everybody. Whether they are EU nationals and we knew that they were in the UK before the 1st of January, or whether we knew that they were coming to the UK after the 1st of January. If they are British, if they have the thickest of Welsh accents, or indeed if they have the thickest of an overseas accent, we still undertake these same checks on everybody. Just for you to be aware, if you do find yourself in a position where you're going to have to get a sponsor license, you may already have a sponsor license or not, but if you find yourself in that situation where you're going to have to apply for a sponsor license in order to sponsor a worker going forward, there are obligations that come with that. So if you find that you have to change the individual's workplace, if you have to make changes to the role, if their salary changes, if a TUPE situation arises, or if you terminate the individual's employment, whether that be by resignation or otherwise, then you're required to update the Home Office. Because essentially, with a skilled worker route and with a sponsorship model, it means that the individual is coming in to work for you and only you for a particular salary, and they're going to be undertaking a particular job with these particular duties at a particular workplace. And that's the basis on which the visa has been granted. So anything that changes any of those parts of the individual's being in the UK, the Home Office need to know about it. I'm going to mention this very briefly. Sarah's already alluded to TUPE, the fact that it's not the most popular of provisions for any employer, nor for the advisors actually for that fact either. But there are implications when a TUPE matter comes into play. So if you are merging with a business, if you're taking over a business, or if you yourselves are being taken over or selling your business to another organization, and there are overseas workers in that mix, then obviously those workers would be subject to the same TUPE transfer provisions as those British workers who don't need to demonstrate working entitlements. However, there are very specific provisions under the immigration regulations. So if you are at a business and you are acquiring workers from another company, you need to be confirming as part of your due diligence whether, on what basis are those overseas workers in the UK. If they are being sponsored by company X, which you are taking over or which you are acquiring, it means that because you're going to be the new employer, you're going to need a new sponsor license. You're going to need the sponsor license to enable the sponsorship of those workers to transfer from company X over to yourselves. And you have to apply for that sponsor license within 28 days of the transfer. So there's a lot of effort going into getting the deal done on a particular day. And of course, there's a lot of post-transfer issues to sort out, but a big one will be immigration. So as part of your due diligence, you do pay particular attention to any overseas workers that might be transferring over to you under 2P. Likewise, if you are an employer and your workers are being transferred to company Y, then you need to make sure that company Y potentially has the sponsor license in place to enable the transfer of your sponsored workers over to it. If we get it wrong, it amounts to illegal working, and that could cost the company up to £20,000 per worker. There are additional reporting obligations. So I mentioned, changes to salary, changes to workplace location, etc. So if the individual doesn't attend work on their first day, or if they take an unauthorized absence in excess of 10 consecutive days, obviously that's going to probably trigger the provisions and your disciplinary policies anyway. But there is also an immigration issue to be dealt with. The Home Office will need to be aware of any employees who go AWOL, because they want to be sure that those employees remain in the UK lawfully. So looking at EU workers, and particularly those who were in the UK before the 1st of January this year, we need to be sure that those workers are aware of the EU settlement scheme. So the freedom of movement ended on the 31st of December last year, particularly at 11 o'clock on 31st of December last year. And EU residents in the UK and their family members must regularise their immigration status under the EU settlement scheme before the 30th of June. It doesn't matter if they don't get a decision before the 30th of June, they must register. Otherwise, what they'll find is that after 30th of June, they might have a precarious immigration status. As an employer, we might not be able to verify their working rights, and landlords might not be able to verify their entitlements to live in the UK. So very important that as employers, we promote the EU settlement scheme as far as possible. And essentially what the EU settlement scheme does, it enables the individual to obtain an immigration status. So if the individual has been residing in the UK for 5 years or more, they'll get settled status, which is permanent residence or indefinite leave to remain, whatever you want to call it, but they have no restrictions on their work. If the individual has not yet accumulated 5 years residence in the UK, then they apply for pre-settled status. And then once they've accumulated their 5 years residence, they upgrade their pre-settled status to settled status. So quite simple. It's based on residence. They don't have to demonstrate that they've been working for that whole time. It's literally just tracking their time spent in the UK. The Home Office might be able to distinguish who has settled status or pre-settled status based on national insurance information, which they can obtain from DWP and HMRC. But there'll be instances where they can't, and what we're finding is that there are certain groups, particularly women and disabled workers, who haven't always had a continuous employment relationships, or who have taken time out from the work context, and as a result there are holes in their NI records. So in those cases, the Home Office may go back to those individuals and say, please provide evidence that you've been living in the UK for the time that you say that you have. If somebody gets settled status, they're entitled to be in the UK indefinitely, but they can also leave the UK for up to 5 years without losing that status. So that's quite important if you employ a French national, and that French national has to be posted overseas for a certain amount of time. So you know that they can do so without their leave being harmed. They can return to the UK without requiring a visa. Those with pre-settled status can leave the UK for up to 2 years. So if I applied as an Austrian and got my status today, I could leave the UK for 2 years and could then subsequently re-enter on my old pre-settled status. However, that individual who spent the full 2 years outside of the UK will harm their chances of getting settled status at the point of accruing 5 years residence, because what pre-settled status regulations say is that you cannot spend more than 6 months in any 12-month period outside of the UK. Now, as a firm, we deal with a lot of corporate organisations where people are sent out to their global operations European centres on a regular basis. And so we're often asked, what is the impact of sending people out on these secondments or posted overseas or what have you. So it is something for you to be aware of, and perhaps to advise the employee about what they're getting themselves in for. If any of the Europeans have family members, they are similarly covered under the pre-settled or the settled status scheme. It's important to realise that if the French national is married to a national from, Malaysia, then that Malaysian is treated like an EU national under UK immigration law. It was the same under EU immigration law as well. So they can apply for pre-settled status or settled status in line with the main visa applicant or sponsor. It's an online process. As I say, we have to just evidence the residence. They do have to declare their convictions or any adverse issues with the police or with the courts. And importantly, they receive the outcome to an email address. So it's a digital decision. They don't get a residence permit. They don't get a certificate. So at the appropriate time, as an employer, we will need to access that digital decision to confirm that those workers continue to enjoy employment rights in the UK. It's a free application. In terms of the time processes, what we're finding is that some applications are decided within 3 hours, others are taking 8-9 months. And it's really difficult actually to determine how long an application will take to be decided. But so long as they've submitted the application, then they've protected themselves. That's the key point. As I said, the key deadline now is the 30th of June. So as an employer, if you know that you've got EU workers, do try to promote the EU settlement scheme as far as possible. And to that end, what I would say is as a Welsh employer or as a Wales-based employer, you can access support from ourselves free of charge. We are one of 3 advice providers by Welsh Government. We have a Welsh Government contract to assist with EUSS applications. So we normally come into businesses, provide management training, we do application clinics, or we're just a straightforward referral service. If you have workers, then feel free to refer them across, and we can get their applications sorted. Our fees are paid for by Welsh Government, and so something that you might be interested in doing. Important, because we are having now to differentiate between EU workers who are coming in before the 1st of January, sorry, and who are therefore entitled to the EU settlement scheme, and those who are entering after the 1st of January, who of course are not entitled to the EU settlement scheme. So what do we need to do as employees for this category of workers? This is where it gets a little bit challenging. So the Home Office have decided that we cannot ask specific questions, and we should not be looking for confirmation of whether a European was in the UK before the 1st of December. So if you have recently, and I say recently in the last 3 or 4 months, employed a European candidate, then you are only required to take copies of their European passport. We're not required to ask, what date did you enter the UK? Because I need to make a decision as to whether or not I need to sponsor you or not. So what employees might find themselves doing is inadvertently employing EU workers unlawfully, because those EU workers entered the UK for the first time after the 1st of January this year. But because we can't ask questions about when they entered the UK, because the right to work guidance hasn't changed, there's nothing we can really do about it. What we're being told is that the guidance will change on the 30th of June. I mean, that to me is wholly unsatisfactory, because if I'm an employer and I've been employing somebody for 4 or 5 months, and then I find out, right, okay, the right to work guidance has changed. I don't know what that right to work guidance is going to look like. We're probably going to be told on the 25th of July what that guidance is going to look like. And if that guidance says, right, we now need to make checks on whether that person entered the UK, well, that's all fine and well. But if that individual needs a visa, then there's quite a bit as an employer you need to do very quickly. And there might not be an appetite on your part to get a sponsor license and to continue that employment. So, how do you handle that from an employment relations perspective? I know as an employee myself, I'd be quite uncomfortable in having this conversation in 6-7 months about, oh, it seems as though you came in after the 1st of January and that you therefore need a visa. But I didn't budget for that. And I need to think about some of those issues going forward. So do keep your eyes peeled for any guidance that's going to be issued nearer to June. But for now, the point being is that you only rely on European documents. We do not need to ask about when the European entered the UK. And the UKVI Home Office have said that they're not going to take any retrospective action. Having worked in immigration for about 15 years, I don't like statements like that, and often the Home Office they can be like a dog with a bone. Once they've got an issue with a particular employer, they won't let it go. So it's just something to be aware of and to factor into your staffing audits and your risk assessments. Just have a think about which workers are European, and how much information do you actually know about them. So with that, because I'm aware that we've only got 10 minutes left, so I'll leave us with this sort of slide. What should we be doing next? Well, we're in the middle of a horrible pandemic, and the economic forecast isn't great. That said, the Home Office are trying to attract more and more visa holders to the UK. They're opening up new categories. Even last week, they were talking about issuing a new IT tech category. So it seems to be that there's been a bit of a U-turn in the government's approach towards overseas workers, in that before December, huge clampdowns, caps, resident labour market tests, making it really quite difficult for employers to take individuals on, restricted to skilled categories, high salaries. All of that has been blown out of the water. So now, more categories, lower salary thresholds, no caps, no restrictions. So read into that as you like, but it certainly shows, I think the message is that the UK is open for business. I mean, we have to take into account that emigration, EU numbers leaving the UK at an all-time high, and so there are going to be gaps in the workforce, and so perhaps this might be an opportunity to do a bit of a project reset to figure out where are your gaps going to be in the next 12 to 24 months. Are those gaps going to be filled by the UK resident workforce, or are you going to have to look overseas? And if you're going to have to look overseas, we have to bear in mind that EU and non-EU, that distinction no longer applies. But with that, for your existing EU workers, do provide as much support as possible to them and make them aware of the EU settlement scheme. There's a lot of soft messaging that can be circulated by HR about making employees aware of that settlement scheme. And as I said, we're more than happy to provide any advice to applicants or to employers without cost. The key point is that these individuals do need to apply before 30th of June. Think about whether you need a sponsor license. With that workforce and skills audit, and knowing that a sponsor license takes about two months to come through, is it worth looking at that now? I mean, a sponsor license for a small company is £536. For a medium to large company, it's £1,476. So we're not talking huge amounts of money. The one license will cover as many overseas workers as you want. So it's not it's not that expensive to have that license. If you already have a license, perhaps you might now want to incorporate your European centres, bring them within the scope of your license so that you can bring workers across quicker and easier under that intra-company transfer route. And then finally, make sure that you review the right to work guidance. If you feel that when we discussed issues about list A and list B at the very start of this presentation, if you feel as though, oh gosh, I didn't really consult list A and list B at that time, perhaps I need to do that now, and just do a quick recce of whether you have all the documentation in place that can verify the entitlements to work of your staff, and then have those documents to hand ahead of any future recruitment. Because as I say, the number of individuals requiring visas and who will have visas in the UK will rise quite significantly going forward. I think that's those are the key points that I wanted to make. Does anybody have any questions at all, or is there anything in the?
Thank you, Glyn. That was really helpful. Some really useful information there for businesses. We do have one question. It's for you, Glyn. Do you want me can you see the Q&A box? It's from Gemma. We're a physiotherapy firm which hold sponsorship, and we do employ workers from the EU. How will this affect our recruitment from now? And then I've read the figure of 30,000 being the threshold unless they come under the shortage of occupation list. So how do we stand, please?
Yes. Okay. So the key point to note is if you identify skills gap and you can't you don't think you're going to be able to fill that skills gap with somebody from within the UK, then the next thing you need to consider is the nationality of the individual. And if the national individual is an EU worker who's in the UK before 31st of December, then you don't need to do anything. Encourage them to apply under the EU settlement scheme. If they don't fall within that category and they don't have an obvious visa, then yes, you are going to have to consider sponsoring EU workers going forward. Now, as a physiotherapist, that is a skilled job, and there will be a going rate for those physiotherapists. With a lot of the health sectors and the education sectors, the salary thresholds are informed by the likes of the Agenda for Change and for the large collective documents that are negotiated at senior at a national level. And so a physiotherapist shouldn't cost more or less in an ideal world, because they're going to be banded according to their experience. But nevertheless, they're going to attract the going rate. We're going to have to pay that physiotherapist a going rate. And the Home Office will set out what the going rates are. They're set out in the immigration rules. And there are two real basic going rates. There's an experienced going rate and a basic new entrant going rate. And the new entrant going rate are for those individuals who have just jumped out of university or are under 26 years old at the time, thereby enabling them to be paid less so that they can begin accruing experience within the job market. If they're not jumping out of a student visa or they're over 26 years old, then we need to pay them the experienced worker rate. And that, unfortunately, is what it is. We just have to pay the going rate. As I've mentioned, there are costs around visas. There's the salary cost, there's the sponsorship cost, there are visa immigration costs. So there's a visa fee. There's also what they call the immigration health surcharge. That's a charge which is raised at the point of submitting an application. It's money that goes direct to the NHS. So anybody coming to the UK, as has always been the case, but will now incorporate EU workers, that's a charge. A proportion of money goes to the NHS depending on the duration of the visa. It doesn't touch the Home Office. But there are, as with what we hear on the news about the problems at the ports in exporting goods, there is bureaucracy, costs, etc., associated with importing labour from outside of the UK, and those come in the form of visa related costs, but also the salary requirements. So unfortunately, if the individual has to get a visa, then they have to be paid the going rate. And I know a lot of companies weren't aware of this before last year, and certainly there are seasonal and agricultural sectors, welders, they're just not going to be able to afford those rates. So you might find that your approach as a business is that you might want to invest more in individuals based in the UK. Certainly as an employer, that's what we're doing. I collaborate with Cardiff University to get some of our paralegals, and we see that as an investment within the firm, and we invest in UK staff. But sometimes you can't pick somebody off the shelf very quickly, whereas you might be able to do so with somebody from outside of the UK. So it's all a balancing act.
Thank you. Then we've got a couple more questions come in. Imran, do we have to do this check on everyone, British nationals? I can answer that. It's yes, obviously the right to work checks apply for all those that we are recruiting, for all individuals. Glyn, have you got anything to add to that?
No. Yeah. Again, you treat everybody the same. So to avoid risks and exposure to discrimination, you'd be undertaking the same checks on everybody. Listen, I've audited a number of businesses, and it's exactly the same position. They say, well, we know this person's British, and then you ask, well, how do you know that they're British? And it's come down to assumptions, or I trust this person to say that he's from Bristol because he's got a Bristolian accent. So unfortunately, no, we have to get the document list set out on list A or list B. So there might have to be some remedial or retrospective assessments, and that's fine. If the Home Office were ever to pick up on it, well, at least we can say that we identified an issue, but we've actually rectified it now. What I would say is, if you're applying for sponsorship and sponsor licensing, you're going to be contacted a bit more by the Home Office because you're dealing with them directly, and so the prospects of you being assessed for whether you're undertaking all the right to work checks, that risk is obviously greater, because the Home Office want to know that you are a legitimate business and that you're recruiting and employing everybody lawfully now, before you get the responsibility for employing overseas nationals going forward. So perhaps if you are thinking about sponsorship, then definitely I would certainly consult list A and list B. And
then finally, couple of minutes over, Gary, I am a freelance cameraman who works for a UK-based events company which organises events in Europe. Is my situation covering these events now?
That's an interesting one, because now there are provisions in place in Europe. This is essentially a European jurisdictional issue. This is now a matter of immigration rules based out in Europe. So not UK immigration rules. So you would need to consult with a particular jurisdiction that you were going to, and to find out what you need to satisfy in order to meet their immigration requirements. Before now, we haven't had to think about it, but obviously, we've got our immigration regime, and mainland Europe will have together with the Republic of Ireland, will have theirs. I should add, just very briefly, because it is important with consultancy and self-employment, there is no self-employment visa in the UK. So you would have to essentially sponsor unless the individual was on some other visa that permitted self-employment, but there is no specific consultancy-based type visa for those working in the UK.
Thank you, Glyn. I think that wraps it up for today. 11:03, 3 minutes over. But I hope you found it useful. Like I said, I mean, we covered a lot of ground today. And if you've left with any questions or want to know more, please do pick up with myself or Glyn. Like I said, we're more than happy to help. But it just leaves me to thank Glyn very much. That was very helpful. And have a good day. All right.